Garima, please proceed.
Yes. No freedom is secure if your property rights are not secure. A warm good afternoon to everyone. I, Garima Shukla, member of EML committee and moderator of the session, presenting on the behalf of Department of Law, Prestige Institute of Management and Research, Indore, would like to welcome our esteemed guest, Dr. Hardik H. Parekh, sir, respected faculties and all dear students. Today, as panelists, we have Assistant Professor Mr. Nakul Singh Chauhan, sir, Student Coordinator Mr. Kshitij Rajpurohit, and we also have members of EML committee, Ms. Muskan Pandey, Ms. Kashish Kamble, Ms. Kiran Vaishnav, Mr. Yash Pathak, and Mr. Vineet Agarwal. It's my great honor to welcome our guest, Dr. Hardik H. Parekh, sir. Sir has pursued PhD in law, and he has graduated in LLB and post-graduated in LLM in IPR from Gujarat University. The area of interest of Sir are intellectual property law, business law, and constitutional law. He has published some chapters in books named Economic Analysis of Pharmaceutical Patent Regime in India, a study in light of pre and post-TRIPS regime in law, and economics market, non-market, and network transactions. Intellectual property crimes as an emerging area of criminal justice system. Issues and challenges in criminal justice system in India, need for systemic changes. Sir has also published in various referred and reputed journals and presented papers in several esteemed national conferences. Currently, he is working as an assistant professor of law in Gujarat National Law University, Gandhinagar, Gujarat. Mere words are not enough to express the glory of Dr. Hardik H. Parekh, sir. In today's session, sir is going to enlighten us about the evolution of right to property under Indian Constitution. If any of you want to ask any question during the session, you can write it down in a Q&A box. We will take the question at the end of the session. Now, I request sir to kindly please take over the session. Thank you so much.
Thank you, Garima, for a detailed introduction. I don't know whether I deserve that kind of the words which you use or not, but I will definitely try my level best to satisfy the expectations. Thank you, Prestige Institutions, for organizing this special session. And this session is very near and dear to me, as the property is very important topic which is near to my heart. My specialization is in intellectual property rights, and I also do teach land agricultural laws in our UG course also, where the basic discussion starts from the right to property. I have requested that students can have an interaction with me because the topic is very interesting. And there are certain interesting observations which we can always have before we discuss. I'm sure you have started studying the Constitution of India. And one of the most interesting part of the Constitution of India is a fundamental right? We are very proud that the fundamental rights which we have received as written form, written form and guaranteed by the Constitution of India is something far more advanced and great than any of the country of the world, right? And that's why whenever we study the Constitution of India and fundamental right, at the same time, the question is always arise that why government take property from us? Do you know that the government has right to take your property, to acquire your property for various purposes? Do you know that the government activities are maximum time challenged? And why this topic is very interesting and important? How many of you have compared the original Constitution, which was prepared, signed, and executed on 26 January 1950, with the signature of all Constitutional Assembly members, with the current edition of the Constitution of India? I'm sure your respective faculty members who would be dealing with the topic might have created interest. In case you have done it, you can raise your hand that you have seen the original Constitution of India. I'm sure you have option in which you can raise your hand and you can show your concepts, etc. Do you have you seen? What is the difference you have observed? No, after the Constitution of India document which was implemented in the 1950, do you know that first amendment took place very next year, that is in 1951. And do you know the reason is because of the right to property. The first amendment in Constitution of India took place is because of the right to property itself. I'll tell you how it is connected. And apart from that, after that, there are nearly 15 different articles you will find out, which are directly or indirectly connected with the right to property itself. One of the major amendments You can always write down in chat box in case you are aware. What are the two major amendments took place into Indian Constitution? Needless to say, everyone will answer 42nd Amendment, 44th Amendment. You can say the Barrett, and you can see, I think there are a lot of books are available in which the consolidated amending articles are available. Maximum articles of Indian Constitution got amended in these 2 years, 1976, 1978. 1976 is a time of the emergency, right? When the Indian Constitution, obviously the parliament procedural was there. And that's the entire interesting historical incidents which took place pre-emergency, post-emergency. And 1978, in the year 1978, the 44th Amendment. In these two amendments are greatly connected with the power right to property also. So why this all point I am highlighting in front of you, I know that being a student of law, when you are learning about the right to property constitution, sometime when you are opening the Barrett first time, we get so much confused that, oh my God, Article 1, Article 2, Article 3, and then immediately when move to Article 12 onwards, then suddenly amendment Article 13, what is required, what is mentioned here, the same is reflected in Article 368. Lot of article repealed, lot of article omitted. Why these all words? And then the situation become very complex. And that is why the right to property is something which has a very great connection with all of them. And today and tomorrow, whatever time we have available, we'll try to see a very interesting story. The discussion which I'm going to make is in part of the very interesting story. And you will also appraise that there is a very great understanding between two powerful organs of the government. You will see in right to property, you will enjoy, like into inverted comma, we can say like wrestling matches going on. And one candidate or one particular player is trying to take dominance on the other, and it is reverted, and it's again replied by the second party. This actually happened, and I'm talking about the judiciary and parliament. That's called legislature. So there is a series of interesting incidents have happened. There are series of interesting case laws reported, and then ultimately contributed a wonderful jurisprudence of Constitution of India. So that's a great discussion which we have and we are doing. So without wasting time, I'll share my screen and let me know once it is visible to you. You can always, yeah, I am sure it is visible to you, right? The screen is visible to everyone. Okay, okay, yeah. Fine. So I'll make it full screen. I am sure full screen mode is also visible to everyone.
Yes, sir.
Okay, okay, that's great. Fine. Thank you for confirming. So now, instead of bringing the attention of all of you for simply the cases, I have some important, particular points or doctrines which are started. So when we talk about the evaluation of the right to property, you might have heard that originally right to property was a fundamental right for all of us, right? When Indian Constitution started or Indian Constitution was enacted, it was a fundamental right for all of us. But today, what's the status of that? We call it as a statutory or constitutional right. So the same article of right to property is taken from Article 19(1)(f) and has been part of Article 300(a). But is it so that right to property is only constitutional right? Isn't it fundamental right? What are the special benefits available to minority education institution? What development has taken place with regard to the right to property as well as the government powers also? So this all things goes with some of the very important combination, and that is called a doctrine of eminent domain. I'm sure all of you might have heard about the doctrine of eminent domain. What do you mean by eminent domain? You can see that the sovereign has given power that they can execute or they can do all the thing what is possible in case it is involving the public interest also. This is a very popular eminent domain principle, right? And government also enjoy the particular principle eminent domain together. And under the same eminent domain principle also, the property is basically acquired, including the land, including the buildings, including the standing crop, also agricultural land also, when there is a requirement of publicness, when the public purpose is involved and it is demonstrated beyond doubt. So the public good is always given priority over the private good. And that's a particular principle or that's a particular aspect going on. I am sure that you might have studied the property jurisprudence as well. There is a separate property laws which are always offered to the students of law, because generally maximum amount of litigations you will find out which is connected with the property. Correct me if I'm wrong. In case you can ask any practicing lawyers, in case you ask all the judges who have seated on the chair and have resolved the disputes, maximum disputes are connected with the property. Either it's a transfer of property, it's a relating to mortgages, creating charge, or the successory rights which are available. So when the property disputes are always there, it is important for law students to study. You might have studied that property is always painful. We always know that property is always painful, and we get the knowledge of the property from our childhood. That from our childhood, generally at this juncture, when you are a student, this may be a premature discussion for us, but just wait for a few more years when you will start running, and at the time a property would be a good investment option for all of us. And when you will invest in a property, a lot of people will say that, see, don't buy the flat, go into remote area, buy a piece of open land, so that after 10-15 years you can get premium prices on that. You will agree, wow, that's a fabulous idea, I should do that. But believe me, the moment you will do that, another question will come in your mind, that I have purchased the piece of land, it's something, it's a remote area, it's a 10, 15 or 50 or 100 kilometer away. How to protect them? How to save it from encroachers? And the moment you do that, it will keep in mind, and you will end up doing sort of lot of other expenditure in order to protect the property. So right to acquire, right to get the property is one aspect, and right to maintain the property is another aspect. And that is why the entire jurisprudence is starting. Our topic is not to deal with the right to property jurisprudence, and that what is the functions of the property, how property gets transferred. For that, you have another discussion which is going on. But our concept is connected with the entire jurisprudence of the Indian Constitution. So this discussion is limited to that also. But I would like to urge you that whenever you learn any topic, doesn't matter you learn Constitution of India or the right to property, try to link it with the other subjects together. Linking it with the other subjects make the study very interesting. You will always get a wonderful incidents. And law is something in which there is a scope of huge amount of stories. There are so much interesting historical incidents have happened dramatically. Like take example of the current situation of the country. Have you observed that currently the right to property is also coming into the preview? You remember, I'm talking about the farm laws. Recently, you might have seen that last, Republic Day in Delhi, some violence incidents took place. Currently, also the opposition is going on. A lot of farmers are, sitting, and you will see the news every day. Do you know it is also connected with the property? It is also connected with the rights, and how dramatically these rights are connected. We are not talking about the political flavor, because then party, this or ruling party or opponent party, this discussion is always coming into picture. But generally, when you want to understand this point, this alone farm law cannot be understood in absence of the another sequence of the story. So when you will start understanding from the 2014, the roots of this new law has been started from the 2014 when the new government came. The development agenda of the new government, what promises government gave to the farmers about the doubling of their income, and how the income of the farmers can get double. Series of papers have written, series of articles are available, you just see, and there are so many commentaries available about the farming structure, and majority of the agriculture expert have given the opinion that there is a middleman, there are APMC market, there is a market exploitation which should be liberalized, which should be given to the farmer. And in light of that, when you study the farm law, you always enjoy. So this is one example I gave. So the property as well as the land and farming activity is not an individual isolated subject. Do same with the right to property also. So keep in mind, I will give reference of lot of other interesting historical incidents to you also, and you can always correlate, and somehow it will help you to understand that why people oppose, what is wrong with the concept of the property, how the dispute started. So this is the very common dispute, and let me tell you, this principle or eminent domain principle is not it's not a new. It is not the case that after the independence of India or after the Constitution of India came into force, this doctrine got adopted. It is available from the times immemorial. In case of the emperors, in case of the rulers, you might have seen the invaders also. When one entire country or one region is invaded, is won by the another, any foreign element, what happens that then the person is sitting as a king, and then he becomes the sovereign authority, and he will decide what is required to be done. And sometimes they become exploitative, sometimes they become very beneficial to the people, and so on. So this, in democratic government, this doctrine is also applicable. So whenever you talk about the doctrine of eminent domain, the debate is always coming that what is the right and power of the state and what are the individual rights. These two things are always coming into picture without anything. So what is a limitation on power of states and what are the individual rights? And recent judgments, I always give reference to the latest judgment. The discussion on right to property starts from the year 1951 with the first judgment of Honorable Supreme Court of India in Kameshwar Singh versus State of Bihar case, right? The Maharaja Dhiraj Sir Sri Kameshwar Singh, and is reaching to 2007 when the same line IR Coelho judgment came, IR Coelho versus State of Tamil Nadu. If you read to the judgment starting from Kameshwar Singh judgment and reaching to IR Coelho, most of the property law development you can easily get it. I have some resources collected and some articles collected for you. I will try to share it. I have apprehension that in case you are a student of the second year and in case all articles are not discussed with you properly, sometime you may feel that it is a premature discussion. But nevertheless, these discussions are very evergreen. So if you have this background in your mind, it will also help you to understand the another articles together. So please explore them whenever it's available to you. So individual rights are there and questions of displacement of legality is available, that when you take the property under the eminent domain principle, what will happen with the people who are displaced, how you will get it. Because whenever right to the eminent domain is available, you have to take the forceful property. So there are people who might be residing on the property of land. There are people who will get displaced. And again, right now we have era of the human rights also. Human Right Declaration UDHR, when we discussed from the year 1948. Right now also we have human right law and incidents of human rights. So everything is coming into picture. So right to property is not again isolated. It's connected with a lot of other things together. So what are the essentials of the doctrine? These two are the important aspect when you talk about right to property. One is there is a public purpose, public use, and number two, compensation is paid whenever property is taken. So generally eminent domain principle don't talk about this particular thing on a louder way. Why? Because compensation may or may not, it is always as per the mercy of the emperor. But when we talk about the democratic structure, compensation has been made as one of the condition. Why I use the word condition? I will show you the article from the Indian Constitution itself. So every government enjoy the right, its inherent right, which is always claimed by them, that we will take the private property, and this principles is used as eminent domain. So more discussion you can study on the eminent domain also. Now there are the two maxims which I think in legal language you might have studied. The solus populi est suprema lex and necessitas public major est quam. That's the welfare of the people is always a paramount law, and public necessity is greater than private necessity. Both the maxims are supporting the concept of the eminent domain, and that's why the government is always taking the shelter of law. I like one particular statement very much, which I would like to tell you, and you can write down and you can always think on that. We are the law students, and this statement is that when you have a hammer in your hand, all the problems you will remember, or you will compare it with the nail. So when you have a hammer in your hand, you will find all the problems are like nails. There is only one option: give a stroke and fix it. Okay. What happens with the law students? The same thing is available when you are a law student, when you are a lawyer, when you are a judge, when you are at government. We have understood the power of law. And the same happen with the government also. So whenever government want to do some welfare activity for the people, there is always an option: make a law, get the property, do that. No, and that's how this public necessity is coming into picture, and these maxims are supporting. Why this point is highlighted? Because one question is always asked, that sir, when I have fundamental right, why government is encroaching my right? And here the answer is given, because I'm sure that all of you have studied that whenever the fundamental rights are available, more particularly the freedoms under Article 19(1), A to G, whenever you read it, Article 92 onwards always include the reasonable restrictions. And this reasonable restriction relating to right to property not directly available right now, but yes, in respect of the theoretical aspect, this will be available. So these two maxims are supporting the preliminary discussion which we made with respect of the eminent domain principle. So government is always having the right. They will encroach the property. They will acquire the property for different kind of the purpose. Now here the question of public purpose is coming. Obviously, the Constitution of India is not giving answer of that, but we have the entire jurisprudence of the land acquisition legislations. I don't know whether it is part of your syllabus or not, but whenever in future you get opportunity, you study that. That's a very wonderful discussion, because in 2013, a new act has come. It's a very powerful legislation which has come. And again, this law have defined what should be the public purpose. So generally government office or public libraries or any project in which some clearance is taking place, rehabilitation of the people is made, the highway transportation facilities, electrifications, university education institutions, irrigation facility, all are part of the greater like. And that's why government always gets the property, and then there are oppositions raised by the party. So this is what is happened with respect to right to property also. So the jurisprudence with respect of right to property available not only India, but in all civilized country, this is available, because all civilized country where the democratic government is there, they keep expecting, people keep expecting something good from the government. And in return, government also promise that we will do that, but we want to have a property also. Now, this is very interesting. At the time of independence, what happened? The entire jurisprudence of the property starts from this. This is the objective resolution. We also remember preamble of Indian Constitution also. So in what was the basic idea? Again, there is a very interesting journey how the Indian Constitution was enacted, how the different meetings took place. And I will request all of you, in case you are learning Constitution of India and you are willing to understand the articles very properly, go to YouTube, and there is a series, Samvidhan, Rajya Sabha TV has created a very wonderful document. There are nearly 10 episodes. You can note down the word Samvidhan. It's very dramatic representation, and I like it. I always tell my students that you read or you please listen to that. There's a small like a web series. If you are watching, it's a small thing. It's available on YouTube, and this is starting from the pre-independence era. In what circumstances Constitution of India enacted? Wonderful idea you will get, and if you are a fresher, you must go. So I recommend you. In case you want link, when the reference material will be shared with you, you can get the link also. So this was the objective resolution. We guaranteed justice, equality, freedom, and we also created certain situation where the pre-independent era, where we were under the British domain and lot of exploitative measures were available. We promised that this should be completely eliminated. And that is why these particular things were available. Now I am showing you one map, and this is what something interesting which I like. Do you know in what circumstances India came into existence, and what was the situation before 1947? This is the pre-1947 map. You are aware about the princely state and British India. No, then the British government said the historical event started from the Battle of the Plassey and Battle of the Buxar. And when the government or British East India Company got a domain, that they started to get the trade license. And afterwards, slowly and gradually, they started taking interest into the politics. And after taking interest into politics, they started to have ruling on the majority of the part of the country. So this, the pink color and yellow color combination is very interesting. Why this is important and highlighted here? There's a reason. Reason is that whenever you talk about the government right, and you are also talking about the absolute power given to the government, we always have a genuine question in our mind that whether government can override their promises which has been made at the time of independence of India, because situation was something different. Let me show you interesting aspect. The pink color are the princely state. Majority of them were part of that. So you can see here the Rajputana or Rajasthan area, including Gujarat area also, including Hyderabad or Mysore or Jammu and Kashmir. Here, obviously the part of Pakistan. So what happened that when independence of Indian Independence Act was passed in the year 1947, a British government decided. So what was the situation? That the two kind of states are available. One is a princely state. So the actual domain, the princely states get all the privileges. They are having a complete sovereign right over their part. Yes, the British government have the guardianship over them. Number two, the United Provinces. So the British provinces, including the Mumbai or central part of the country, central provinces are here. Somewhere it is highlighted. The United Provinces in Madras Presidency. This all presidency completely got independence. So now they were completely having freedom. So they can decide what is required to be done. But the princely states were given a choice that now we are removing guardianship over you. You can choose whether you want to be with the United India or you want to be with the Pakistan. And that's how the entire dramatic incident started when the India and Pakistan, the partition took place. Now here, one of the important, interesting object is that when these all princely states were declared to be free, how come they will be part of the United India? Let me show you some important figures. And this is the important figure. You will find out there were 554 princely states which are controlling 28% population of the country. These princely states and their particular the population is available, area is available. The biggest one is Jammu and Kashmir. You can see the area. It's a nearly 2,22,432 square meters. Then Hyderabad, then Jodhpur, then Mysore, then Gwalior and Bikaner and Jaisalmer and Rewa. Even in Gujarat, Kutch. So total area is 9,91,669 square meters of the area, square kilometer, sorry, my mistake, square kilometer area is under the princely state. Why this is discussed with you? Because when you talk about the right to property, keep in mind the promises. Now, how come this all princely states come? They have army also, 75,300 soldiers they have, and this all princely states have their complete domain. They were celebrating their festivals. They were completely having their domain. Some of them had their currency also. They had the railway lines. They have the public utility things also. All the things. Needless to say that when there is a king or emperor and when the successors are getting, they also get this particular rights together. Now, in order to merge this all princely state with the government of India, you all know what happened, that at the time of Sardar Vallabhbhai Patel, this instrument of accessions got signed. In case you are interested, you can read the instrument of accession. What were the promises? That against the right which they are waving up from their particular princely state and they are becoming part of the United India, they are ready to abolish their titles. They are abolishing their particular situation. Like, the king of Jammu and Kashmir or king of Jodhpur or Mysore will now not be considered to be the king. They will give all revenue rights to the government of India. Government of India is allowed. They can make any kind of changes into the state territory, state boundaries, which is also available by separate schedules of our Indian Constitution. Against that, they were promised the privy purses. I'm sure you are aware about that also, that this all kings were allowed that when you are giving away all your rights on your particular states, we will promise you, the government of India officially promised them, you will be given privy purses. And when the privy purses are given, along with that, their personal properties were secured, that they can have their personal property, only the property which is in the public domain, the property of the other citizens are mixing with the government of India. And against that privy purses, and that too there was a condition that privy purses will not remain same. With the generation, it will get decreased. So suppose right now, if the existing king is getting 100 rupees as a privy purse, say for example, if he is no more, that the next generation will get some percentage less, and accordingly one day all the privy purses will get abolished. This was the official promise which was given or which was made by the government of India with the all princely state. And these princely states are available in a huge quantity. Now imagine where they are promised that their property rights will be identified, where they can have their individual property, they can have their palaces, they can have their agricultural lands, and they can do the activity. Suddenly, when the government will start the activities, they will have problems. So that's why what happened, this was the one thing, instrument of accession. Apart from that, the concept of social security was there, and that's why these 3 articles were added. So when you see the original Constitution of India, I asked you in the beginning, these 3 articles were available. Right now they are not there because they have been changed. So Article 19(1)(f), Article 19(5), and Article 31. These 3 are the very basic articles which all of us have to consider when we understand the right to property. Let's see one by one, because right now, in case you are searching the original Constitution, you can read the text of this article. Otherwise, in the current latest versions of the Constitution of India, these articles are not available. So Article 19(1)(f) is providing like this: all citizens shall have right to acquire, hold, and dispose the property. So with the all 6, this was total 7 fundamental freedoms. Right now this is not there. So right now we have 6. So this fundamental freedom was there, that you have complete right. You can acquire, hold, and dispose the property also. There is a reasonable restriction which is available, like other thing, that the state can impose reasonable restriction on your right to property in interest of the general public and protection of any scheduled right. So this was the reasonable restriction, that in case of general public interest is available, state may come out with some of the scheme by which your right can be not exercised. Along with that, Article 31 was there about the compulsory acquisition of the property. See, this article was also there. Today, this article is not there. Rather than we have 31A, 31B, 31CD, this article, and again from that also this article got repealed. What was the original text of Article 31? Read it, and then we'll try to understand it. What was the nature of right to property? Various clauses of Article 31, Clause 31, 31A, Article 31(1). There is a person can be deprived of the property only by authority of law. So right now, the way you have right to property, but in case your property rights are required to be deprived, there should be authority of law. What is authority of law? You are aware, right? That it is established under the law. So there is no any kind of the discretionary or any kind of the authority which is using the exercising the power. They are their proper statute, and based on the statute, the authority is available. Number 2, clause number 2, property will be acquired only for the public purpose and on the payment of compensation. So when you want to acquire the property, you have to take it for public purpose only, and compensation is condition prerequisite. Now, compensation is also a very tricky word. The original property holders, I told you that maximum people who were owner of the property read this compensation word as a fair compensation as per the market value. But what government thought, that it is compensation. Compensation means compensation determined by the government. Okay, so we'll try to understand and note down this point. This will come in all the cases which you'll see. Kameshwar Singh case or IC Golaknath case, Keshwan and Bharti case, even IR Kohelo case, and other series of the cases also. Everywhere this dispute is very common. So according to this article, because there is nothing added after compensation, so property owner will always say that it is compensation, means whatever I can get from the market value, I will get it from the government. But government is thinking that no, we will pay what is reasonable according to us and what is our treasury permitting. So this was clause number 2. Clause number 3, if any law is passed by the legislature of the state, it will come into effect only if it has received the assent of the President of India. So this is completely unitary nature, that if a state government, because we know the federal structure where state government is also allowed to take the property for a public purpose and central government is also allowed. But when the state government want to take the property, they will have to take the assent of the President of India. That's compulsory, because then the central government who have given the wide powers under this particular provisions can always have a monitoring. Otherwise, all state government with the different political ideology may come out with the different law, and there can be a completely mess with respect of the state ideology, which is not advisable at the time when India has got the recent freedom. And that's why this was the condition. Clause number 4 is very interesting. Any legislation which is passed by the state legislature and received the assent of the President, you cannot question in court of law on the ground that it is contravening a provision of Article 31(2). What is Article 31(2)? Public purpose and compensation. So when state government has made the law and when it is assented by the President, you cannot question, because before giving assent to the certain law, President has presumed to understood the provisions, technicalities, whether public purpose is solved or not, and then only they have given the assent. So you cannot question in a court of law. Number 5, clause number 5, 31(5), protection to the existing and future law enacted for the purpose mentioned therein. So there were certain laws like, Article 13, we have also pre-constitutional laws, post-constitutional law. So this provision, and Article 6 is, clause 6 is very important, that any law, no law of the state enacted not more than 18 months before the commencement of the Constitution of India, and within the 3 months of such commencement has received the assent of the President of India, shall be questioned on the ground that it contravened the provision of subsection 2 of 299 of Government of India Act 1935. So this clause is talking about the timeline, that if before 1950 you take the 18 months time, if at that time the law has been made or passed by the state government, but immediately after Constitution of India within 3 months it has got assent, then you can again not question that it has bypassed section 299(2) of the Government of India. Government of India Act is not in our syllabus, it is not taught, but for a ready reference, this particular provision has been added. It is mentioned neither federal or provision, because the Government of India Act nomenclature, they were not using the state or central government, rather than the word federal or provincial words were used. So no federal or provincial legislature shall have power to make any law authorizing the compulsory acquisition of the public purpose any land or commercial or industrial undertaking, or any interest in any company owning or commercial industrial undertaking, unless law provides for the payment of compensation for the property acquired, and land either fixes the amount of the compensation or specify the principle on which the matter which is to be determined. So this is again giving the power to the people that generally the federal or legislature and provincial legislature shall not have. So these are the 6 important clauses. Now what was the, apart from that, you are aware about the 3 lists. So these are the few entries in a list number 1. There's a union list, state list, and concurrent list. And these lists are also dividing the right to property aspect. So I told you that nearly 15 articles you will find out in Indian Constitution, which are talking about the particular thing. You can take a screenshot of that, or you can take this presentation later on also. There are all the entries we are talking. Like what is example in entry in list number 1, there is entry 33, which is talking about acquisition and acquisition of the property for purpose of the union. So list 1 is a union list. So in any case, government of India want to take, they have power, they can make a law. So I'm sure you are aware that article 246 schedule number 7 is talking about the legislative competence. So who can make law for what? So what happens in union list? The central government will have a power to make a law, state government shall not. In the case of the state list, state government shall have power, central government will not come. And concurrent list, that's a very unique mixture, that both of them has power. Central government will make the law, state government shall follow that, or they will make a rule. So generally, central governments are passing the law, state governments are taking the action by making the rules, and accordingly the enforcement of the laws are taking place. So entry number about acquisition of the property for central government is completely right of the central government. In a list number 2, there's a state list, there's an entry 36, which is talking about the acquisition except for the purpose of union. So if state government want to acquire, their legislative competence is available in entry number 36 of list 2. And entry number 42 in a list of 3, there's a concurrent list, compensation to be provided determined in principles on which it is provided. So this is something tricky, that both the central and state government have got legislative competence to get the acquisition of the property. But when compensation is required to be paid, then there is a schedule number 3, there's a list 42, entry number 42, in which compensation may be determined by the central government, and state government may accept it or may come out with the rule also. So these are the 3 important articles which are available. So when you read article 31(2), you can see that compensation is a condition, that whenever you take the property, compensation has to be paid. No forceful property can be taken without payment of compensation. When you read clause 4 and 6, the legislations are also protected, that whenever the property will be acquired by government, they will get protection, but this is very limited protection, because in case article 31(2) is violating, then only these things are coming into picture. And apart from that, it was felt that the provisions are sufficient to protect the right to property as well as the government right. So why these 3 articles have been shared with you, that you imagine and you can understand the principle, the position when independence of India is there. So you have fundamental right of property, you have reasonable restriction, and you have also article which is a little bit controversial, but it's expected that they will be able to protect. So that's why these 2 things were protected. Number 1, right to property. Number 2, the legislation which are providing. Now the dramatic change is taking place. Here there will be very interesting change. You will find out what is it. What is the change aspect that you will find out in a particular article in case of the Kameshwar Singh. Now, in case you remember the political situation of that at the time, all of you might have studied about the land and its holding position. Generally, when we talk about the right to property, land is a major one. So what was the situation? What was the situation about the tenants? There was the committee which was committed, enacted by Justice, J.C. Kapparam. If I'm misspelling it, please forgive me. But at the time of independence, a special committee was appointed for the land reform. Why land reform? Because we have seen the bitter fruits, that how zamindari system came when British government was there. They created a hierarchy that they want to collect the land revenue. So in order to collect the land revenue, they will be appointing certain zamindar, and this zamindar will either be a big landholder, or he will be cultivating land personally, and then he will be keeping certain tenants. And these all tenants and peasants will be giving land revenue, and then zamindar will be depositing land amount to the government. And that's how the entire revenue structure came into existence. But we have seen that it was very exploitative. It was not resulting into proper, food security also, because when you are supposed to pay the higher amount of land revenue, your concentration will not be on the land development, rather than you will be always focusing that how I am able to meet with that. Again, very stringent law. You also might be knowing about the bonded labor system. How come the bonded labor system came? So when sociological changes are taking place, suppose my grandfather had taken certain amount of loan from zamindar, and when he is unable to pay, zamindar will grab the land. Now your land was under the charge, so I will take the possession of that. Still, the huge amount is pending. Even though the land has been given, the amount is not paid. So what is happening? That after that, the zamindar will give choice that, okay, do one thing. Now you become the tenant, you cultivate the land, and I will pay you some salary. And from that salary, you have to pay me the interest. Until the time your interest is not paid, you cannot leave the job. And that's how the bonded labor system started. So exploitation of the tenants, bonded labor system, a huge landholders. The people, some people are there who are very poor. They don't have even a single square meter of the land. But some people are having villages and villages. And that is why the government of India came that we have to seriously think on that, and we have to do some kind of reformative action. What reformative action took place? Two sides. Number one, they come out with the land reform legislation. Okay, right to property disputes are starting from this initiative, because government came in after the election took place. When government came into existence, they thought that now let us abolish zamindari, because these zamindars are always having presumption of becoming exploitative. So we'll abolish zamindari. We'll try to make a law in which ceiling limits are fixed. Do you know what is ceiling limit? That how much maximum land a person can own. Today also ceiling limit, ceiling laws are available. There are two kinds of land ceilings: urban land ceiling and agricultural land ceiling. Urban land ceiling will come when your land is situated in the urban area. It's in outskirts of the cities, and when the land is not agricultural, it's a purely commercial or residential land. Lot of state government, including Madhya Pradesh, including Gujarat, including Bihar, Uttar Pradesh, came out with the Urban Land Ceiling Act also. But somehow some state governments' law could not sustain in a court of laws, and that's why they got struck down. But agricultural land ceiling is still available. So in government will come out with the cap that if you are a farmer, maximum land on your own property on time you can have this much square meter, not more than that. In case you are having more than that, it will be considered to be the void agreement. So this initiative started. Now, obviously, now what happened? That Bihar Land Reform Act passed. So there is an act named Bihar Land Reform Act. This act is very popular because when you will see Schedule 9, this is called umbrella legislation. I will explain why it is called umbrella legislation in a coming slides. In Schedule 9, the first land is Bihar Land Reform Act. Okay, what was the Bihar Land Reform Act? It was the act which was declaring that the zamindars, and see, this is the important basic aspect. What was provided? That from the date which is mentioned in the act, all zamindars' estate and successor shall stand extinguished, and it will waste into stand, and compensation shall be paid as per the principle which are provided in the act. Okay, so this was the act was passed. See, it is in the year in 1950 only, where you have right to property, you have right given to the government, but at the same time, government wanted to come out with the reforms. They wanted to redistribute the land. So redistribution is possible when you completely remove the title. So this was the basic purpose. Obviously, it was challenged, and the challenge was made by Kameshwar Singh in all textbook. You will find out the citation of the case Kameshwar Singh versus State of Bihar. But original title of the Kameshwar Singh was Maharaja Dhiraj Sir Singh Kameshwar Singh. Why? Because he was a king. He was having a huge piece of land. Obviously, there were other zamindars also. And when Kameshwar Singh being a capacity of the king, when he has a huge area of land, this law will also impact his land holding. And based on that, he challenged that this is absolutely useless activity by government. I want to challenge it. And what was the ground of challenge? You will surprise that it is violating Article 14. See, tricky. You will also understand that how different writ petitions are filed in court of law under Article 32, under Article 226, and how you are able to pursue the court that how my fundamental rights are violated. Generally, it is my of India, we focus on reading articles only. But I am showing you one very powerful formula. In case you really want to understand the constitutional provision, read any writ petitions. We have a subject advanced legal drafting at our GNLU, and I take the subject. So we teach students how to draft writ petition. A lot of students who do internship, who are going with the corporate advocates, or the advocates are reading. But I am telling you that even though you are a student of the second year, you take, right now it's always available that how writ petitions are drafted. Any constitutional writ petition, read that how the lawyer has pursued it, that how their fundamental rights are violated. And believe me, once you are reading a writ petition, which are recently in recent past, so many writ petitions are filed. You take about Article 3, the Shah Banu case, when even triple talaq case was very popular. The LGBT rights, that writ petition, the judgment given by Supreme Court, even Aadhaar case also. So there are some landmark judgment relating to constitution. You read the judgment, no problem. But if possible, you read the writ petition also, the original petition memo, which is submitted by the person in court of law. This reading writ petition will always help you that, okay, this is written in Article 14, 19, 15, 21, or etc. And this is how it is interpreted by the advocate. Wonderful knowledge you will get in the beginning. So this writ petition was challenging Article 14, that this entire law, which is declaring abolishing zamindari, is wrong. Why? Because there's a different formula. See, this is the formula which was mentioned. It was mentioned that compensation shall be paid. Means the Bihar Land Reform Act, which was challenged, it was deciding that, okay, if you are zamindar, we'll take your land, we'll pay compensation. But in case you are a poor landholder, then it will be 20 times compensation. But if you are a rich landholder, it will be 3 times. Meaning thereby the land gave a formula that this is X amount of compensation per square meter of the land. Now, if you are in a category of the poor, we'll pay you 20 times because you have a huge loss because your entire land which was utilized for livelihood is getting snatched. But if you are a rich, then you are not getting affected. So we'll give you less amount of compensation. What was the result? Court got convinced. High Court got convinced, and they believed that even though right to property is a fundamental right, but yes, government has reserved the right to property, but we cannot allow this kind of the difference of amount of compensation, more particularly when the compensation is made a mandatory condition under Article 31, which is not there, but I show you the text of the article. And that's why the Patna High Court uphold the petitioner's contention, and it was declared. The matter went to Supreme Court of India. Supreme Court also gave the same opinion that this particular observation by the Patna High Court is absolutely correct. And that's why the Supreme Court of India held the Bihar Land Reform Act is unconstitutional. But at the same time, in Madhya Pradesh, there was another law, Madhya Pradesh abolition of the proprietary rights. And in Uttar Pradesh, there is a Uttar Pradesh Zamindari Abolition and Land Reform Act. These two laws were also challenged in respective high courts. And when they came to Supreme Court, they were held to be valid. Now, here there is an interesting point that I told you the historical background. There are princely states, there are kings, there are zamindars who were given guaranteed rights of the holding land by the British government. And suddenly there is a change of the government. The socialistic pattern government has expected. This is available in objective resolution. This is available in preamble of Indian Constitution. Again, it is available in directive principles of the state policy. So under this all provisions, Indian government is supposed, it's a mandate that you have to do something which is very positive for bringing the equality in the society, for decentralization of the wealth, for taking care about the poor downtrodden who got exploited. And that's why government is doing the activity as per their mandate. In between, this judgment came. So because of this judgment, what happened? The government had to get a setback. And that's why it is said that this entire judgment was found to be a setback for government, because with the provisions like this, Bihar Land Reform Act, abolition zamindari, entire country, the government started the agrarian reform. In every state, they came out with this kind of law. And it was felt that if the Supreme Court has taken this stand, it is quite possible that in the same line, another writ petitions will file, and all this writ petition will create a hurdle, because judiciary is also a very powerful organ. That's why what was the answer? That government applied their mind. Okay, we also have power. And then all articles of the Indian constitutions were used, and they made an amendment into constitution. I told you the first amendment into Indian constitution was because of this right to property. What amendment was brought? That it was enacted, inserted 2 articles, Article 31A and 31B. And this Article 31A and 31B, obviously at the time Prime Minister Jawaharlal Nehru ji was there, and it was passed in the year 1957. Later on, it was ascended also. So this was the Article 31A. This is available very much. You can see this. It is mentioned that the saving of law providing for acquisition of estate. See, Article 31 is already there. But in order to repeat what has been stated in Article 31, 31A is there. Notwithstanding anything in foregoing provisions of this part, no law providing for acquisition of the estate or any right therein, or for extinguishment or modification of any such right, shall be deemed to be void on the ground that it is inconsistent with or take away any of the right or provision in the part. So why? Because Patna High Court and Supreme Court held that this law is violating Article 14. And that's why this article was added in the same line. Apart from that, that was one more article, 31B. And article 31B is creating schedule number 9. Both of these are available together. Like when you refer 246, schedule 7 is referred, article 31B, schedule 9 is referred. And it is mentioned in article 31B that none of the act specified in schedule 9 shall be deemed to be void on the ground it takes away or abridges any part of the rights conferred by the part 2 of Indian Constitution, part 3 of Indian Constitution. So 2 articles government thought. So you can see now the wrestling is starting. That first judgment came by the Supreme Court, in which the action of the government is completely held unconstitutional. You can't do that. Answer of the parliament is, I told you that when you have a hammer in your hand, all the problem you will find it like a nail, and you will try to give a stroke and you will try to fix it. What parliament has law-making power. And at the time, there is a majority government because the Congress party, Jawaharlal Nehru ji is leading. And when there is a majority of the power, because today there is a situation where you have different kind of the political parties and the coalition government and this one. At the time of independence of India, we have won the battle of the freedom. So everyone is going in the same direction. So there is no question about the majority, etc. So with the help of this power, the parliament was enacted. Now, afterwards, what happened? That they wanted to add the law. So first law is Bihar Land Reform Act. I told you that in Schedule 9, when it is called protection, this is the reason why it is called umbrella legislation. In case you have not read about Schedule 9, you can read it again. That whatever laws are made part of the Schedule 9, for that government had to follow the procedure. So they will make an amendment, amending act will be passed, and under that act it will be mentioned that government is henceforth adding this law under Schedule 9. And that's why the moment law is in part of the Schedule 9, you can't question. So this is in a way taking the judicial review power from the court of law. Are you getting? So the stroke by government is taken. Yeah. Is there anything? Okay.
So we are running out of time. So
yes,
maybe...
yes, I know. Okay. So I will stop here. I will start the discussion from the next class. You can do a small homework, which is the case which is challenging this move of the government. You can come out tomorrow. You can come prepared tomorrow. So I'm stopping here and waiting for question answer. Yeah.
Any one of you have any questions, you can write it down in a Q&A box. We will take it.
Sir, in the meanwhile, if you permit me, can I ask one question?
Yes, please, sir.
Sir, so let me just inform you that I'm not a law faculty. I teach management. I teach BBA LLB students management subjects.
Yes,
but I was listening to your session attentively. So, sir, you spoke about the Privy Purse and how it was promised when the Treaty of Accession was signed. But sir, eventually that Privy Purse was abolished by Indira Gandhi in 1971. So don't you think, sir, that it was very unlawful of the Indian government to do so? Because I think the signing of Treaty of Accession was premised upon the kings and the rulers being given the Privy Purse. Those were the conditions.
Yes, I included that. That's a very interesting story. When I discussed the legislation with them, there are 2-3 very interesting incidents in which there is an entire series. Like you can create a web series also. I tell generally we see that only some like Chetan Bhagat's novel is very popular, but I tell that Indian Constitution also have historical incident. So in emergency, what happened in emergency? That's a very dramatic event took place. I discuss all the events with the student that this is actually happened on this day and one by one. Same happened with the Privy Purse also. In Privy Purse also, I have one wonderful observation in what circumstances got abolished. It was observed by government that all princely states were ruling the government. They were collecting land revenue and they were doing a lot of charitable works also. When they signed the instrument of accession with India, they become completely free because their governance power was taken. Now what happened? Then they started contesting elections. So you must have heard about Gayatri Devi ji. There is Gayatri Devi's name. She was so popular that she defeated Congress, the participant also. And then government thought it's a threat that we are giving money to the people, and this all kings and emperors and once upon a time good people are using the same money, and they are standing in front of us. And that's why at the time abolition, Garibi Hatao, the power given, the abolition of poverty, Garibi Hatao, that was a very common. Under the Garibi Hatao scheme, all the Privy Purses got abolished. This particular instrument was passed. There are so many interesting episodes which I can share. There is a story of the Maharaja Karna Singh. In case you have heard about Maharaja Karna Singh, at the time,
Jammu and Kashmir.
Yeah, in Jodhpur, in Rajasthan, I forgot the exact name. what happened that at the same time, highest amount of tax rate was there. 97.5% taxation we had at the time it was paid. I know some of the students will find it's very strange. Today we have 10%, 20%, 30% tax slab. We have seen the time when 97.5% taxation rate was there. It was having estate duty. Maharaja Karna Singh's name is very popular because he had to pay 150% tax. So what he did, his all assets were taken. He had to sell his personal property and then he deposited the tax. This was the time. So yes, it's absolutely correct. Obviously, this privy purchase got challenged in court of law. Apart, R.C. Cooper is a very popular judgment. You know, R.C. Cooper, along with privy purchase, the bank nationalization also took place. This all took place, but I tell you that power of the parliament superseded all the things. So there is a clear observation. You know, when it was challenged in court of law, but before the court came out with the judgment, again the amendment took place. The same happened with the right to property also. The remaining portion will complete tomorrow. So this is, it was absolutely unfortunate event. Lot of people have given lot of observations also. But the conclusion comes that right now in the democratic system, the power of the parliament is supreme. And that's how it happened. And that's why I tell that when you read this story and then you read the constitutional article, all the development you can very quickly grasp. And you can also think, generally, it's our observation that when we are a student, we simply read articles and then we simply mug up and then we write down in our examination. After a few years, we never know that what was the reason. But I have my observation that if you link this event, you can link it. So thank you, sir, for asking this question. Even I have the opinion that yes, it was something which was very misfortunate, unfortunate with them. But you know, what else? Because power of parliament, power of government has been seen. And the judgment. This is not class for that, but in case I will get opportunity, I will share that article, that what actually happened, what was the court stand when this judgment was challenged before the court of law also.
Sir, and another major event that happened was the Keshwanand Bharti case. So after that case, the basis on which the Chief Justice of India was selected, the seniority basis was ignored. And then it was seen that the Supreme Court was in favor of the government.
Yeah, that is also one of the, you know, thing, but still this discussion is still going on. I'm sure you are aware about, the judicial appointment bill. Recently, the judges should not be selected by the collegium. Rather than government came out with the law, the Judicial Appointment Commission, NJAC. What happened? The moment it got notified, implemented, Supreme Court struck it down. So there is a very good debate about between the parliament, government. Yeah, we believe that judges appointment is completely, it's not in government's hand also, but still the discussion is going on. So it has great connection. Yeah, there is also an interesting incident that a kind of the, rebate, or you can say incentives were given, Chief Justice role is coming. So that's a altogether different, discussion. But yeah, the observation is correct that things are coming into picture slowly gradually. But there is no any comment on that because generally what is happening, that's a supreme power, and we are respecting the dignities of the court, and with due respect, we discuss all the things together on a public platform like this also.
True, sir. Thank you so much for answering my question.
Yes. Any other question? I think in chat box some questions are there. Just 1 minute.
One question asked by Manjeet Singh Jat. Sir, he has asked that whenever government is taking private property of individual, is government always giving fair amount of compensation to the individual?
No, the answer direct is no. Reason is the Land Acquisition Act, because here you have mentioned the government acquisition. When acquisition is taking place, till 2013, we have the old law, land for acquisition. There's a 1894 legislation. That legislation was not talking about the market value. It was always talking about the fair value. So what government was doing I'm sure you have heard about the Registration Act. Whenever you sell the property, you have to pay the stamp duty. And that stamp duty is having, it's called Jantri rate, circle rate. In different state, different names are there. So minimum amount of stamp duty, what should be collected by government has fixed the price. So generally compensation is paid as per that, but it is very below than the market value. Finally, in case you are possible, you read the 2013 Act, which has made a powerful calculation of the market value. Section 26 of 2013 Act is talking about the market value, how it should be calculated. So right now it is hope that if your compensation is calculated under the new law, it can be very near to the market value. That is a new hope. But in old Act, it was not the case. Where there is a, in case, I don't know in which semester you are learning the Land Acquisition Act. Are you offering the subject Land Acquisition Act in any of the semester?
Sir, we are offering land laws separately as a subject, but that comes in the final year.
In final year, when you will study the systematic calculation, in case you don't want to wait for that, you go to YouTube, you watch the documentary, Crushed Dreams. There's a name documentary, Crushed Dreams. And then in a dramatic incident, it has happened that how the land got acquired what happened with the usage of the land, and what other questions are connected. So obviously, I told you that all subjects are interlinked. There is no separate subject. When you talk about the land law, Constitution of India, environment, all the things are connected. And as I taught land law today morning only I had class, so we discussed all the point together. So yes, compensation is also very less. In case government is acquiring property got vacant after fulfilling the purpose, can the owner claim? No, as per Yash has asked the question. As per the old law, there was no provision. But 2013 Act, Section 101 is providing that if the land is acquired by the government and if it is kept vacant for 5 years, there is a provision to return the land back to the landowner. This is the recent provision which is under the new law. So old Act was silent. There was no provision to return, but new act has taken care about that provision also. So accordingly, you can study that point.
Okay, sir.
Yes, thank you, sir.
Yeah.
Now we will move forward to the vote of thanks. So I would like to call Vineet Agarwal to give vote of thanks. Vineet, over to you.
Thank you, Garima. I, Vineet Agrawal, on the behalf of Department of Law, PIMA, would like to express my sincere gratitude to Dr. Hardik H. Parikh, sir, for sparing his valuable time and for his thought, giving us precious knowledge in abundance. I would also thank Assistant Professor Kamlesh Jain, sir, for organizing today's EML and for his vision and guidance at every step. I also thank Assistant Professor Navrati Dongre, ma'am, for her presence during the session, and also to Professor Nakul Singh Chauhan, sir, for his support throughout the session. Sincere thanks to student coordinators of EML committee, Ms. Priyanshi Jain, Mr. Nishan Jain, Mr. Kshitij Rajpurohit, and other committee members for making this EML a true success. Most important thanks to all the dear students for being patient and gaining all the knowledge and lessons calmly. Thank you.
Thank you so much, sir.
Thank you so
we'll
much.
meet
I
tomorrow.
hope to see you tomorrow and with some other
We look forward
development.
to your session tomorrow, sir.
Thank you
It
so
will be
much.
great. It will be
Thank you
a
so
very
much,
good
sir.
learning experience
Sure.
for me too.
Thank you so much. We'll see you tomorrow.